So before we start, I'd like to ask Ms. Jones, Mr. Ruiz to call the roll.
Get set up here.
All right, I'll call the roll here. On the platform, Commissioner Barunda,
Here.
Commissioner Brancard,
Present.
Commissioner Fry,
Here.
Commissioner Arms is not on the platform, absent. Commissioner Laney,
Present.
Commissioner Langer,
Present.
Commissioner Moender,
Present.
Chair Thompson,
I'm here.
Commissioner Bayless.
Here.
Commissioner B. Hill.
Here.
And Vice Chair Zemlik.
Here.
Okay, we have a quorum.
Thank you, Mr. Lopez. So just a quick recap. Yesterday, we considered the red line markup that was the hearing officer produced based on our April meeting. We changed it rather dramatically. We decided not to allow pilot projects to discharge water outside of the industry. And then when we, at the end of the day, we decided that we would ask the Environment Department to establish a permit for pilot projects that were treating produced water. Commissioner Brancard offered some suggestions, and late last night, our hearing officer, Ms. Felicia Orth, took it upon herself to try and incorporate those suggestions into a draft language that would go into the regulation. She finished it at midnight, sent it around this morning, and I don't know if it's posted on Docketed Matters yet.
No.
But I believe all of the commissioners have an electronic version of it. So what we're going to do today, I think, is we'll start with that. This was the language, and I've forgotten. It was 400. It was 20.6.8. 20.6.8 point. I'm trying to find it here. 400 part C. Is that correct?
Yes,
And
Mr. Chair.
20.6.8, 400 part C is now titled Produced Water Pilot Project Permit. So that is my brief summary of what we did yesterday. Is that more or less accurate? Yes, the commissioners.
So, Mr. Chair, I would just make two observations. One is, in order to find the edits that I made and distinguish them from all the other edits that have been made to Exhibit 175, I put a little tiny black star, the little star that you find on top of the 8 on the keyboard, in front of anything that I changed. That included the 4 changes, the 4 minor changes identified by Select Water Services, and then the longer stuff that arose from the Commission's decision yesterday. So if you do a find or a search function on the little black star, you can find all the places I did anything. The only other observation I would make is that, as I mentioned yesterday, I incorporated the changes that Commissioner Brancard and you and the others had wanted as briefly as possible with reference to 20.6.2, 3108 through 3113. But I also note at the very end that Center for Biological Diversity, Wild Earth Guardians, and frontline community members and NEE had also set out a pretty full narrative of a permit process at the very end of their proposed rule. It would have been a new D and E, and you would find that by looking at pages 41 through 44 of attachment A to the hearing officer report, or of course the closing arguments from NEE and the others.
Okay.
Marilyn, that's a possible that you send that out.
Before that, to
Yes, so I will.
Thank you. I don't know if everyone heard, but counsel for New Energy Economy requested copies be sent to the parties. And so we'll take care of that. And I assume it will appear on docketed matters as soon as possible.
I'm going to load it up right now.
Thank you. Okay, so we ready to start on 400 Part C? Looks like we are. So the first paragraph, 400 Part C, subpart 1. It's pretty straightforward. It's any person intending to use produce water for an authorized pilot project under subsection B of 20.6.8.400 shall submit to Groundwater Quality Bureau of the department. And this is the new language, an application for a produce water pilot project permit prior to use. And again, new language, and shall not proceed with the project until the application is approved. Anybody have any heartburn with that? Okay. What's the pleasure of the commission? Do you want me to read these things? You all have it in front of you, so perhaps we can just go through it line by line. I mean, we can go through it at each section. You can, if anybody has any concerns. Okay. We're getting some unintentional noise from the web. If everyone would please mute themselves. Okay, so 400 Part C, subpart 1, subpart A deals with applications shall be on a form provided by the department. Anybody have any heartburn with that? Okay, and under that, 400C 1A Roman numeral I, name and address is required. Roman numeral 2, location of the intended project is required. Roman numeral 3, concentration of contaminants is included. Roman numeral 4, the quantity of water used in the project. Roman numeral 5 is the research plan and objectives. Roman numeral 6, again, stop me if there's something you want to discuss. Roman numeral 6 is documentation that the project design is consistent with the uses. In subsection B, Roman numeral 7 requires secondary containment and plans for monitoring to detect illicit discharges.
Mr. Chair, that last phrase was added as a result of your comments yesterday.
I appreciate it. I think that's important. Section 8 is unchanged. Plan to transport in and out produced water, treated produced water in a safe manner. Section 9, plans for safe handling and proper disposal of the produced water and any materials that come into contact. Section 10, plans to minimize the risk of human exposure. Section 11, financial assurance. And section 12, looks like that's been removed.
If I might, Mr. Chair.
Thank you.
When I went to 20.6.2.3108, it was clear that the application had to include basically the applicant's form of proposed notice, form and manner, and locations. Then there was a determination of administrative completeness. And then following that, that basically was the trigger, the precipitating event for all kinds of other things in 3108. So I tried a couple different ways to just refer to 3108, but to me, it became clear that there wasn't a way to do it without calling out that precipitating event. So that's why the new subsection 12 would be their proposed notice, locations, et cetera, which would be part of the application. And then a determination of administrative completeness is below that. And then at the top of the next page, you see a whole new subsection 2 that contains all the other references to all the other sections in 20.6.2. I wanted to say that.
Okay, is that clear? One thing that I think should be in the permit application, and I don't see it, and again, we all just received this morning, is I don't see any mention of how the applicant will handle any wastes that are generated by the treatment process.
Oh, sorry, Mr. Chair, that again is something that was captured in proposed E by NEE and the other groups. Is the disposition of the produced water at the end of the project. And so that's why I was referring people to pages 41 through 44 of attachment A.
So I understand, and that is handling subsection Roman numeral 9 talks about plans for safe handling and proper disposal of produced water and any materials that come into contact. That's not the waste necessarily.
Mr. Chair, it's pretty brief. I'd be happy to read it. Again, this is capital E. You find it starting at the bottom of page 43 of attachment A to the hearing officer report. Final disposition of treated produced water, untreated produced water, treatment byproducts. And well, this says components of bench scale and pilot projects. I understand bench scale would be deleted. And it just says all disposal of untreated produced water following a project shall use one of the following methods. Referring to a produced water disposal well permitted by OCD, delivery surface waste management facility, also permitted by OCD, or disposal in a permanent pit. And then the second paragraph, all disposal of treated produced water, treatment byproducts, components of the project, must characterize the waste and adhere to all local, state, and federal regulations for non-exempt, potentially hazardous waste as applicable.
Mr. Chair,
Commissioner Brankard.
back further in subsection B, there's a that's where the more elaborate discussion about disposal is in. Okay, B8.
Correct. I'm referring to section C1, which talks about applications. And I think the application ought to talk about how they're going to handle this. Other thoughts?
Isn't it there though in B, well, 9? Plans for safe handling and proper disposal of produced water, any materials that come into contact. That doesn't cover what you just asked?
It probably does. However, I think there should be a separate item in the application that specifically deals with residuals, with waste residuals and its management.
Chair Thompson,
Yes, ma'am.
I have a question for Madam Hearing Officer. So the pages you were referring to in your appendix or attachment A, which ones were, I'm sorry, I was looking for them at the time.
Right at the end, pages 41 to 44.
Okay, got it.
Commissioners Chair, I was going to offer a thought. So I think that as far as the application, what has been provided where it talks about plans for safe handling and proper disposal is explaining that the intended party who's applying for a pilot project permit has to have those. I think what you're looking for is some safeguards to say that once the pilot project reaches completion, they're going to dispose of it in a correct manner.
Yes.
I would suggest that that's not necessarily part of the pilot project permit, but that it should be part of the rule in a later section. That's my 2 cents.
Again, I think it ought to be part of the application.
Chair Thompson, I agree with you. This is Commissioner Fry.
So, sorry, Commissioner Laney, my only argument there is that when they're making the application, they don't already have treated, produced, or untreated produced water. They would have that after they've carried out their pilot project.
Commissioner Brankard.
Well, I guess I don't understand what's missing from 9. And I guess I'm a little cautious about getting too specific about disposal because these projects will be all sorts of shapes and colors, and we don't know exactly what is going to be left at the end. And so I think it's up to the applicant in coordination with the department to figure out how to properly dispose of this stuff.
Chair Thompson, may I?
Yes, Commissioner Fry.
So, somebody had pointed out that 9 lists plans for proper disposal of produced water. Could we just add and waste generated in the process? So I'll just clarify my thought on this. It needs to be part of the plan of what will happen to the waste. There needs to be they need to, just as they're listing plans for transport, plans for safe handling, they need to have plans for the proper disposal, not only of the produced waters, but also of their waste.
Commissioner Chair.
Commissioner Lehner.
Yes, so reading it, it appears to include that it has the produced water and any materials that come into contact with the produced water, including soils, plant material, treatment equipment, and containment area material. Do we need to be more specific than that? Okay, and what would that specificity look like?
If I may,
Commissioner Fry.
I think if we just say and waste from any process. The problem with the wording now is it doesn't distinct, it just says produced water, materials that come in contact with untreated produced water and treated produced water. It doesn't speak to the waste from any purification process. And that's what I'm saying needs to be in there.
So that wouldn't be included, I'm sorry, under the treatment equipment.
I think it could go.
I know I'm not
under-
arguing. I just want to make sure we put together a good definition and that it's not creating redundancy.
So this waste that's going to be produced as a result of these pilot projects is going to be really different. You know, it's going to be concentrated salts. It will have radionuclides. It may have organics. My preference would be to actually include a separate item, subsection Roman numeral 12, which would say plans would require determining the volumes, masses, and characteristics of waste regenerated by the treatment and how they would be managed and disposed of. So let me give you a little bit of personal history. 4 years ago, I designed and built a pilot desalination plant that I operated at the Biggendorf. This is the Brackish Groundwater National Desalination Research Facility, BGNDRF, I think that's the acronym, at Alamogordo. And one of the requirements, it's a facility that's operated by the Bureau of Reclamation. One of the requirements was I had to specify the volumes, masses, and characteristics of the waste that my pilot plant would produce. I think that's a reasonable expectation. You know, if they're designing a plant, they're going to spend tens, hundreds of thousands of dollars. That is not an unreasonable expectation to ask them, what are the characteristics, masses, and volumes of the waste and how are you going to handle it? Commissioner Fry.
You now have me convinced to have a separate section that includes the volume, characterization, and what else did you list for the waste?
Mass, the volume, mass, and characteristics, and how it would be disposed of, managed and disposed of.
So mass, because you want to know the density of the product, is that?
Yeah.
Okay. I would agree with that.
Commissioner Reinhardt.
Let me offer a possible set of changes here. Okay. In this subsection 9, after the word handling, insert comma, characterization. Okay. And then after the third line, the end of it, treated produced water before including, insert in any other waste generated by the project. Okay. And then maybe when you get down all the way to data reporting, which talks about lab analyses, etc., you could add a provision in there that lists all waste generated by the project.
I'd accept that. I would prefer a separate section, but I would accept that. Commissioner Laney.
I agree with that suggestion in that we could just add to this a little bit, and I think it would hit all the points that you guys are hoping to make. And I actually agree that I think they should have to have some data that shows the volume, the mass, the characterization. I think we need to add that in the data reporting section for sure.
Thank you. Okay, so it's been proposed and I've reluctantly accepted the amendment. So section 9, I'm going to recite it as best I can, would subsection 9, Roman numeral 9, plans for safe handling, disposal of produced water. No, plans for safe handling characteristics, volumes, characterizations, and volumes, and proper disposal of produced water. And Commissioner Brancard, would you please read your suggested?
Okay, so
'Cause I'm
plans
confused.
for safe handling, characterization, and proper disposal of produced water, any other materials that come in contact with untreated produced water, and any other waste generated by the project, including soils, plant material, treatment equipment, containment area materials.
Okay,
Did I say that too fast?
Could I, this is Commissioner Fry. The way it's worded now, it adds more weight to the soils, plant material, treatment equipment, and containment area materials. I would like to see included in there, including waste from pilot project processes or something to that effect. Because I think what Chair Thompson was getting at was the waste from the processes is in my mind as bad or worse than what's going into the system because you're concentrating the waste. So it feels important to me to state that specifically.
I added the phrase, and any other waste generated by the project. Does that cover what you were thinking about?
I guess, why are we stating specifically soils, plant material, blah, blah, if we're not gonna be clear about what waste we're talking about?
Because we don't know, and we want to make sure that includes soils.
Could I offer a slight suggestion?
Commissioner Laney.
So, sorry, after including, we could just put any or all, perhaps all waste materials, soils, plant materials, treatment equipment, and containment area materials. Would that more accurately reflect, because you said there was emphasis on the soils and all of those listed, would that add the same emphasis in your opinion?
How about waste including, would concentrate be clear enough? I mean, it is for me, but I don't know about the rest of the commissioners.
The industry uses the term residuals. I think waste is probably sufficient. Okay. Further thoughts on Commissioner Brancard's suggestion?
Just for a legal clarification, whenever the word including is used, by law, it means including but not limited to. Okay.
I understand
Yeah.
that. That's used commonly in any writing. We're naming so many things in there, and to have the concentrate, or I forget the term that Chair Thompson used.
Waste.
It's important enough, I feel like, to name.
Stick with waste, I think. Either waste or residuals. Waste is common language. Residuals is what the industry is going to because it's less inflammatory. So, digressing. We used to call them sewage treatment plants. Now they're water reclamation facilities. Okay. I'm seeing heads nod that we agree to Commissioner Brancard's suggestion. All right. So let's go on to down there at the bottom of page 13. There is a new subsection 12 offered by the hearing officer that refers to proposed locations and newspaper for providing notice of the pilot project. Does anybody have concerns about that? Okay. And that refers to the requirements for permit applications set out in 20.6.2.3108 NMAC. Okay, let's go on to subsection B. Says, and forgive me, that's subsection small b, says the department may request additional information. Subsection small c, based on the information provided, the application, I'm losing it, shall determine whether the application is complete. Any thoughts about that? I said I'm losing it because there's a lot of red line strike through and it was hard to follow, but it's a simple sentence that says that based on the information provided, the application, the department shall determine whether it's administrative complete. Okay. Seeing no concerns about that. There is a new subsection 2. Should I just read it? It's a little bit longer. It's a paragraph. Following a determination that the application is complete, the applicant and department shall proceed with the further public notice and participation requirements set out in 20.6.2.3108 through N and 20.6.2.3110 and the relevant evaluation and action requirements set out in 20.6.2.3109 and 0.3111, the plans of the required applicant in section C1 shall be incorporated into the pilot project permit as enforceable conditions. Appeals from the secretary's decision and the commission's decisions may be taken in accordance with 20.6.2.3112 and 0.3113. Seems pretty straightforward. Thank you.
Yeah.
Okay, moving on. Data reporting requirements. Okay,
I think that should be section 3.
Yes. The renumbering is going to have to occur regardless here.
thank you. So data reporting requirements, subsection 2 small a is unchanged from our previous version. Any concerns about that? Subsection 2 small b, persons implementing the pilot project shall submit monthly reports. Again, I'm summarizing very quickly. If anybody wants more details, go ahead and answer. Commissioner Laney.
Yes, thank you. Would you like to add in here, what frequency would you like to see the volume characterization and mass? I believe those were the, would you be inclined to see that as part of the monthly reporting and annual reports, a new subsection? I felt like you sold me on the idea that that's important data to have. I just don't know necessarily the frequency of reporting that might be necessary for that.
That's a good question. For a large, I think it depends on the size. If it's a large pilot plant, many hundreds of barrels a day, I think it would be appropriate to ask for monthly reporting. If it's a small pilot plant, just a few barrels a day, a couple thousand gallons a day, less frequent reporting would probably be required. I don't know. I don't know how to write that into regulation.
If I may,
Please.
we require monthly reporting for some of the elements of our program. And if they say they haven't started carrying out their project, they can simply report 0. There's nothing that says that you can't report that you haven't used any water and you have no volumes to report on. I think it gets challenging to keep track of if you establish separate reporting frequencies.
Commissioner Zemlik.
Thank you, Chair Thompson. I agree, and I think monthly reporting for all of the reporting gives the department the ability to monitor how the project is going and identify any issues too if the reporting indicates that there's a problem.
Okay, I agree. So we'll stick with monthly reporting. Seeing heads nod. Commissioner Laney?
So then we would potentially need to add your volume characterization and mass to B, subsection B. Is that an appropriate place to stick it or elsewhere?
So this little subsection, small b, says shall submit monthly reports for all liquid streams, which would be include liquid waste streams. I think we should also include liquid and solid streams. Liquid streams and solid waste. That make sense?
Chair Thompson.
Yes, ma'am.
So,
Commissioner Fry.
Thank you. So, it says with water quality data for all liquid streams, the addition should be and volume mass characterization of solid
Yeah.
waste.
Yes. Yes. Is that clear? So we'd add another phrase after the phrase water quality data for all liquid streams and the volumes, mass, and characteristics of solid waste. Okay. Commissioner Brancard.
How about ending that phrase, any solid waste disposed during the period? Because you talk, I mean, it's disposal that you're concerned about. What got disposed? I mean, if something's a waste and it's simply sitting there in the lab.
So the waste would also be the liquid stream. So I guess I'm not clear what you're suggesting, because in the plan, they would always already state what they're getting rid of. Or are you thinking they need to state exactly what and how they're disposing of it?
Well, I thought the idea was, say, every month you report what waste you disposed of that month.
Okay. Yeah, I like that.
Okay. I'll accept that.
So how is that going to be wording? Because I just, in reading the sentence, we're asking for monthly reports with water quality data for all liquid streams. So it will then be and waste. I'm not quite sure how it's going to read. Can we clarify that?
I think Chair Thompson had that already.
Well, it would say water quality data for all liquid streams and volumes, masses, and characteristics of solid waste disposed of during the month.
Chair Thompson.
Commissioner Fry.
I have a question about, so the characterization, is that the phrase you used? I'm sorry.
Characteristics.
Characteristics. Is that only like a physical description you're thinking of, or would it need to include chemical analyses?
Characteristics is used in RCRA, the Resource Conservation and Recovery Act, and that includes the chemical properties as well.
Do we need to say as defined in such and such? Because otherwise it's kind of unclear what you mean by characteristics. Or we could say physical and chemical characteristics.
I would accept physical and chemical characteristics. Commissioner Laney.
Thinking. So the data that we want is the water quality data, right? We want to make sure that these pilot projects and achieve and demonstrate their water quality. Do we need to have like a full characterization of the waste material? Is that important for understanding it? I just need some clarification because I'm not an academic. I don't live in that world. So maybe that's important, but I think we've captured the water quality data is important. This whole rule is being built to understand what the water quality is and to get more information on that. Do we need to characterize the waste material to the degree that we're talking about, or do we just need to make sure that they're disposing of the waste material in a appropriate fashion?
Okay, this is not an academic question. This is a question for the design of the final prototype. What is your waste going to look like, and how are you going to dispose of it? So, yeah, I think this is important. And I also think it's important to the public that they know that the material that's produced by this, which could be pretty nasty stuff, is safely and properly handled. Commissioner Fry.
An additional clarification, in my mind, that solid waste could be more hazardous
Oh,
than the liquid
absolutely.
waste. And we really need to have that. We need to know what's going into our waste stream.
Commissioner Brancard.
Mr. Chair, I also think that given the different varieties of projects that the Environment Department in a permit document can clarify more specifically what they want to see from the applicant.
Good point. Thank you. Okay, are we done with that one? That's Arabic number 2, small b. Let's go to Arabic number 2, small c, which deals with department shall publish on its website all applications and supplemental information. That seems pretty straightforward. Yes, okay. So at the bottom of page 14, New Energy Economy and CGFCM, I've forgotten what that stands for.
Center for Biological Diversity, Wild Earth Guardians, and Frontline Community Members.
Thank you. Proposed a new section D and E that were not adopted. So the hearing officer has not suggested any other language beyond that which we've just considered. Is there anything that we need to include in this? Commissioner Fry.
I was just going to ask if you could clarify your question. Include in what? In what's here already, or are you referring to a possible new section D?
Correct. There is no further material provided after section after section C, which is on page 12. Do we want to add any other language after that?
Thank you.
I'm seeing heads shake. So I think we're done with section 400. Mr.
Mr. Chair, can we go back to 400B, which we sort of skipped over?
We didn't skip it. Go ahead.
So 400B3. I don't think the hearing officer made the change.
I did.
It's got an asterisk.
It has this little star. Conduct a pilot project, right? And then the business about in accordance with 1201, that was a decision you guys made.
Right,
in
but the last
April.
line,
Oh, notice of intent. I missed that one. Thank you. In the very last line, it says notice of intent, and it should say produced water pilot project. Yes, thank you. Permit application. Thank you for that.
and then do we want to deal with subsection 8 on disposal?
Could you elaborate on your thoughts there, Commissioner?
Well, there's a shall in there, and it refers to 3 disposal methods under the oil and gas regulations, which I'm not sure are appropriate. Maybe they are, but maybe they aren't for these Environment Department permits. So I'm wondering if we could, I mean, there's sort of a savings clause at the end, which we noted last month, talking about the department may consider alternative disposal options on a case-by-case basis. But I think this is sort of where the provisions in the permit lead back to this more general concept that they have to dispose of in an appropriate way, obviously based on the characterization of the material and approved by the department. And so I don't know that we need to list these methods under the oil and gas regulations that may not be appropriate to the scenario. But disposal is obviously important, as we just went through a whole bunch of discussion about it.
So,
Commissioner Laney.
thank you. So you're suggesting maybe we don't list them, but is it appropriate to reference them? I think, I don't know. I don't want to leave it too open-ended. But I don't know if it's, I agree. I'm not entirely sure if we need to list them. I don't know if reference is appropriate.
Chair Thompson?
Commissioners Fry.
I would, since this was provided by NMED, I would like to keep that language, but I think we could say, so a person's disposing of blah, blah, shall use an appropriate disposal method, including and the list.
I'm fine with that as long as we say shall use an appropriate method approved by the department,
Yes, thank you.
including, which may include following.
Chair Thompson, I have a question.
Mr. Zenlik.
I think we had discussed this in the past, but is there a scenario in which, because pilot project and the water associated with it is no longer under the jurisdiction of the Oil Conservation Division, that disposal methods under what's described here would be denied?
I think the answer is obviously yes. I mean, you take produced water and you use it in a non-oil field project, say, greenhouse project growing alfalfa, And then your waste stream, that's not really not necessarily oil and gas produced water anymore. Now, again, as I said last time, I think the Environment Department needs to have a serious conversation with the US EPA because most of this stuff, the produced water itself, will go down an injection well, and it depends which injection well you need to do. And as some of the parties pointed out, it could end up being characterized as hazardous waste if it no longer has the exemptions that it had before, depending on what level of characteristics of components are in that waste.
Well, and especially the solid waste or
Yes.
concentrate byproduct. So that is to say, I agree that that having additional options as determined by the department, and the case by case reference satisfy me.
If I may, this Commissioner Fry, at the bottom of 8, the very last sentence says the department may consider alternative disposal options on a case by case basis. So is that what you were looking for?
Well, I was generally pointing out that even with a liquid waste stream that looks like produced water still, there may be cases in which the disposal method cannot be conducted via a class 2 well, and those are generally available in the areas where these pilot projects would occur. And so as long as, and maybe that's a conversation with the EPA, because then if you assume that you can use 19.15.26 of the code under the Oil Conservation Division, and you cannot, it would impact the cost of your waste handling and a variety of other things. If you assume that you can still dispose of the liquid waste stream in a class 2 well. So, given all the demand on class 2 wells.
I'd like to go back to Commissioner Fry's observation. This was proposed by the department. I don't see that this constrains pilot project in any way, referring to the oil and gas regulations in some what respects provides a little bit of reassurance that they will be in compliance. So my preference would be to leave it as is. Commissioner Laney.
So I'm just making an observation, but in the attachment A, one of the recommendations, I believe from and group, yeah, was that they had the very last page on 44, they have a 2, all disposals of treated produced water and any treatment byproducts or components of the project must characterize the waste and adhere to all local, state, federal regulations for non-exempt, potentially hazardous waste. Would it be prudent to consider adding that so that if they do have a conflict where the oil and gas industry says this isn't produced water anymore, so therefore it can't go back into that system, there's a statement here kind of helping address that? Does that help the applicant and provide the clarity that we need?
This is Commissioner Zemlick. I personally like that because I realize that NMED proposed that language, but that's NMED proposing to know that the Oil Conservation Division is in agreement with that. And it's not, I agree that it covers case by case, but it's sort of taken for granted that the oil and gas codes and statutes will apply and be an option for applicants.
Chair Thompson?
Commissioner Fry.
I like your thought on that. I just want to point out 9 talks about persons disposing of components of a pilot project blah, blah, must adhere to all local, state, and federal regulations as applicable. Does that say the same? Is that close enough meaning, do you think? Or are you thinking to add that wording on page 44 of the report to one of those?
I think Commissioner Laney, I think 9 is really close, except for it doesn't deal with the scenario if a produced water which has been treated then no longer can be taken back into the oil and gas loop, if you will. It doesn't account for those waters. What would happen in those cases? And NMED could probably address this on a case by case basis. So we may be making a mountain out of a molehill. I just was offering it up for consideration. It does at least give some loose guidance if you do have water that is treated that perhaps oil and gas won't put back into their loop, then you'll have to look at it as hazardous waste and comply with all of the requirements of local, federal, state, federal, etc.
Chair Thompson, if I may.
Commissioner Fry.
So are you thinking to add that sentence to 9 or integrating it, or what are you thinking?
This is Commissioner Zemlich. I just wanted to add to your thought process too, is that 8 is, it seems to be speaking more toward the water and byproducts, and number 9 I read as all of the components, the physical components of the project, the membranes, the equipment that has to be disposed of afterwards.
I agree. I mean, it's all about how you interpret component, I suppose. Water could be considered a component, but 9 is very specific, or 8 is very specific. It's water used in the pilot project. Whereas, so if you're thinking, okay, I just read about what happens to the water, and then you get to 9 and it says the components, they seem to be separate. So the components would have a different pathway. I think the water potentially needs to have that same pathway if the oil and gas industry won't take it back into their disposal loop.
So I
Chair
think we're,
Thompson,
let me, Commissioner Fry, go ahead.
so for me, just rereading a real quick read through what's in the report from the hearing officer. The main difference I see is it says must characterize the waste. Well, that's it. That seems to me the main piece that's missing. So maybe we could just include that in these. Sorry, Chair Tom.
No, that's fine. I kind of feel like we're going in circles here. Can you help me out? Do we want to keep section 8 or change it? And if so, how? Well, I'm looking at 8. That was the one that Commissioner Brancard brought up because it refers to the OCC regs. And then we could go to 9. Commissioner Brancard,
Well, I mean, I made a proposal, but then we kind of went
sideways.
off. And so I thought we lost my proposal. So
Chair Thompson.
Commissioner Fry.
I think, correct me if I'm wrong, Commissioner Brancard, I think what we were proposing was to add what was it? It was something to the effect of shall dispose of, I think it was oh man, yeah, we lost that. We shall use one of the following methods in accordance with relative permit. Shall dispose of any waste as approved by the department, I think. Was that it?
Commissioner
And-
Fry, I wrote down the exact
Oh.
words. Shall use an appropriate method approved by the department, which may include one of the following methods.
Commissioner Brankard?
That was what I was. Well, you're right. Commissioner Fry actually made the proposal.
which Commissioner Branker agreed with. And I think that's an important change to make.
Okay. And Ms. Orth, you've captured that?
I did.
Okay. Would you, for my benefit, would you please read the whole thing?
Certainly. Persons disposing of untreated or treated produced water as part of the final disposition following a pilot project shall use an appropriate method approved by the department, which may include one of the following methods in accordance with the relative permit. And then just the rest of that.
Okay. Thank you. All right. Is everybody comfortable with that? I'm seeing heads nod. Did we want to change subpart 9, which deals with disposal of components of the pilot project? Commissioner Fry? You don't want to change it?
Could you repeat the question?
The issue is, do we want to change subpart 9 on the top of page 12? I'm comfortable with it. But there was a little bit of discussion. Commissioner Fry.
I guess my feeling is that number 9 addresses what we were discussing, but I think there was some other concerns by this Commissioner Lane had brought up that other sentence that was in the hearing officer's report. And my point was the only difference really was that the requirement that whoever's running the pilot, who's ever writing the report and running the pilot project must characterize the waste. And I don't know if we've covered that down below or if we need to add that here.
The way I read 9 is this deals with disposal of all of the material at the end of the pilot test. So if you've got contaminated pumps, membranes, and things like that, I don't read this as a requirement during the operation. Disposing of components of the project.
Also, if I might,
Yes, ma'am.
to further confuse it, but if you continue from the 9 in B down to the little tiny 9 under C, also required are plans for safe handling and proper disposal of produced water and any materials coming in contact, soils, plant material, treatment equipment, and containment area materials.
Yes. Thank you. Mr. Fry.
I'm fine with that. Then on B, however, I think hearing her rereading C, I think we still need to. Which part of C was that again? So I can reread it.
The little IX representing 9.
It says any materials that come into contact with the water. I still don't think we cover the waste well enough in that section. I think we need to, because it's saying coming into contact. The waste, I don't consider that coming into contact. I think it should say plans for safe handling and proper disposal of produced water, waste generated, and any other materials that come into contact with the produced water. And that would satisfy me.
Sorry, I think that was revised earlier. I think what you were reading was the existing language, but we just finished revising that. The little 9. That's what we just moved from revising little 9 to include your concerns about the waste, disposal of the waste. But I think what you were reading was not the revised version.
That's true. Thank you, Mr. Ugarte.
Thank you.
Earlier, Mr. Brankard had read some language and any other waste generated by the project.
Thank you.
Okay. Let's go through this one last time, not line by line. Looking at section 400. 400A deals with general requirements. Does anybody have concerns about what is contained in 400A? 400B is a description of the authorized pilot projects. And it describes what is authorized, how the waste materials are handled, both the treated produce water and solid waste. That last section, section 9, which we just discussed, talked about disposal of the materials at the conclusion of the demonstration project. Any concerns about that? Okay, 400 part C deals with the permit. Okay, any concerns, suggestions? And again, that has a new section, subsection, small b and small c. It refers to data reporting. Any other comments or concerns about section 400? Hearing none, I think we're ready to do something different. What time is it? You know, yesterday is my fault. We abused the court reporter. Before we start on something new, let's take a 15-minute break and we'll reconvene at 10:30 and then see how far we can get. So we'll reconvene in 15 minutes. Okay, let's we'll talk. We'll talk.
Okay.
Let's reconvene. It's a little after 10:30. So we've dealt with 20.6.8.400 rather at length, which deals with produce water reuse. Let's go back to the beginning, to the very beginning. Let's just go through it section by section. Most of there are no changes. So is that agreeable to everyone? Okay, so 20.6.8.1 is the issuing agency. 20.6.8.2 is the scope. 20.6.8.3 is the statutory authority, which deals with the Water Quality Act and the Produce Water Act. 20.6.8.4 is the duration, and we agreed last April that this would have a a little over 5-year term. It expired December 31st, 2030. 20.6.8.5 is the effective date, and my understanding is that will be determined by State Records Office.
Right. My understanding is the department staff will work with the record center to put the rule in a finally acceptable form and to identify which issue of the register would be published in, and then what the effective date would be following that.
Okay. 20.6.8.6 is the objective. That's unchanged. 20.6.8.7 is the definitions. Now we changed quite a few of the definitions, eliminated a bunch last April. So let's just quickly go through there. We terms beginning with A, we eliminated agricultural application. We eliminated application. If anybody has any concerns, just stop me. Terms beginning with B, we eliminated bench scale project. Terms beginning with C, we eliminated commercial application. Terms beginning with D, we eliminated demonstration project. We kept department. We kept direct potable reuse. We changed it from application to reuse. We kept discharge permit. We eliminated discharge plan and discharge site. We kept disposal. We kept domestic wastewater. Terms beginning with E, we kept the term environmental buffer, although that's, yeah, that deals with potable reuse of domestic wastewater, municipal wastewater. Terms beginning with F, we kept feasibility study. We eliminated flood irrigation. We eliminated flowback. We eliminated food crop application. We eliminated formation water. Terms beginning with G, we kept groundwater, which is defined in the Water Quality Act. Terms beginning with H, we got rid of hydraulic fracturing. Terms beginning with I, we changed it from indirect potable application to indirect potable reuse. We got rid of industrial application, industrial project. We kept injection. We got rid of irrigation application. JK, terms beginning with L, we got rid of land application and livestock application. Terms beginning with M and N, there are none. I'm sorry, terms beginning with N, we kept National Pollutant Discharge Elimination System. We eliminated NTU. We kept NPDES permit. Terms beginning with P, we kept person. Terms kept pilot project. And we added a clause at the bottom that I think we might want to revisit. It says pilot project shall have a daily produced water capacity equal to or less than 2,000 barrels per day. And that came out of some testimony. One of the parties said that we misunderstood that. We want to revisit that 2,000 barrels per day. Commissioner Fry.
How important is it to keep that last sentence? I mean, I know we were trying to be specific, but can we leave that for NMAD to define on a per permit basis?
Thoughts?
Yes, thank you, Chair Thompson. Commissioner Zemlik, I I don't know what the basis for it is. It was proposed, I'm looking at attachment A, less than 2,000 barrels per day. And then I very unscientifically reviewed the existing projects and agreed with that amount the last time. But I don't know what to cite to because I think the expert testimony by Dr. Balch had a much smaller value. Like less than 100 barrels a day, I think. I'm just trying to remember. So I'm kind of tending to agree with Commissioner Fry in that the department might determine what that is.
Other thoughts? So if I understand correct, you are suggesting that we take that last sentence out.
Yes. I think the 2,000 barrels per day is as arbitrary as it was noted that it was for discharge as it is for pilot project size, at least from what I can find in the record.
Mr. Hightower provided some verbal testimony. It was not written testimony describing pilot projects. I believe in Texas that were between 100 and 500 barrels a day. I could go either way. Mr. Laney.
Thank you. I'm in support of just omitting the last sentence, using the definition that the Environment Department proposed and allowing for them to determine the scope of a pilot project in review of the pilot project permit.
Other thoughts?
Mr. Chair, Commissioner Branco, another issue I think we didn't also address that you brought up is duration of the.
I'm sorry?
Duration of the permit? I don't think did we put that in the?
No, because yesterday when someone said, how about let's keep it at 5 years, someone else pointed out that the rule is sunsetting in 5 years. So maybe there was supposed to be a sentence in there that the permit should only be issued for up to 5 years, because if the rule sunsets, but someone just got a permit a year ago, and the ordinary language, says basically a permit continues until changed or revoked.
Yeah, that is to the best of my recollection, it was a discussion we had yesterday.
Mr. Chair, Commissioner Belander. So I've not had any, this is just purely on the mechanics of how regulations work. A duration is, the lawyers and judges would probably greatly appreciate a duration. So that way it's very clear, because if there's a lapse at the end, like say the regulation sunsets, there is no permit at all, which I mean would terminate it, and it could create a certain element of vagueness. So I would encourage that discussion as someone who works with these things an awful lot.
That's very helpful. We'll go back and revisit that in just a second. Let's deal with this, whether or not we want to put a cap on a pilot project. I've heard two suggestions that we remove the capacity of a pilot project. Just let NMAC staff determine what constitutes a pilot project as opposed to a demonstration project.
Mr. Chair, if we don't put it in the rule, I think we ought to establish that the Environment Department will put it in a permit. In other words, the permit will define what the maximum capacity is.
I think that's a good suggestion. I noticed that NPDES permits all have maximum capacity of the treatment plant. So I think that's a good suggestion. So let me, if I understand, what we're going to do here is we'll remove the cap maximum capacity on pilot projects. But before we finish today, we'll go back and put a clause in the permit that establishes what the capacity is. Is that agreeable?
Mr. Chair, so it does already require that the application include all of their plans, the plans for volumes and all of that. And then I did insert something to the effect that the plans need to be incorporated into the permit as enforceable conditions. So does that take care of it?
Commissioner Laney?
In my opinion, it would, because they've specified this X amount of volume is what they intend to use as part of their plan. And then because of that language that you included, if they use greater than that amount of volume, there would be some enforceability that they could take place at that point.
Commissioner Molander, let me ask, since you've got experience with the permits, if an application says one volume, and then during the conduct of the study, they exceed that volume, is there an enforcement strategy that can rein them back in?
Generally, yes, you can, that could result in like a notice of violation of some kind, depending on the gravity, the severity of it. Like if you exceed it by 100%, that's more likely to garner enforcement attention rather than if you exceeded it by like 2%. But regardless, if there's a baseline that's in that permit, that is the metric by which the performance will be judged, and anything exceeding it would likely technically be a violation.
But we're not talking about the permit, we're talking about the application.
Oh, the application. You could apply with an excess, like if there's a reg that says there's a fixed volume, for example, and you submit one that's in excess of that, that wouldn't necessarily be. So we're talking, well, I want to be careful here because I managed to tap dance around the particulars of this reg, and I don't want to cross that to preserve the ethical issues that I've got. Applications usually are not going to be analogous. And in fact, I can't think of an instance where an application is analogous to a permit. So you can kind of submit generally anything you want in the application. And I've seen that across multiple agencies. Now, what happens after that is going to be contingent on the rules and whether permits issued or whatever the case may be.
Commissioner Brankard.
Well, it's quite possible that somebody will come in with a pilot project that is way beyond the scale of what the Environment Department would consider to be an acceptable pilot project. And I think having a rule that says the Environment Department will set the maximum capacity in the permit gives them a little more heft in the negotiation, which I mean, I understand Commissioner Moander, we've dealt with that a lot, particularly like with injection wells, where somebody will come in and go, oh yeah, I know the policy has been X, but we want to do 3X, And so, you're sort of left with, well, what's our authority to stop them?
I would concur with Commissioner Brankard on that.
So how do we move forward? My preference would be to identify, put a capacity in the definition of a pilot project. If we don't do that, and even if we do that, I think perhaps it's specified in the permit. But let's deal with this first. Do we want to put a maximum capacity in the definition of a pilot
Chair
project?
Thompson.
Yes, ma'am.
So, I thought what I just now heard being proposed is we don't put the capacity in the definition. We put that into the sections following. And so we need to address that. We need to address capacity and we need to address duration.
Yes. I think that's right.
Okay.
Okay, so are we going to strike the capacity that's in the definition of pilot project? Mr. Brancard.
I mean, I think the concern that you've set out is that there's not a lot of evidence in support of a particular number here. Also, we have to deal with the issue with that has obviously confused some of our participants about how many gallons are in a barrel.
Chair Thompson.
Yes, ma'am.
Clarify, I thought that was part of the discussion is further down in, not in the definitions, but further down in the rule, we would state that the NMAC defines what
Yes.
this is.
Yes, that'll be part of the permit.
And so therefore we don't need to be specific in the rule.
I think everybody agrees with that. So we will strike that in the last sentence in the definition of pilot project. Okay. Now, Commissioner Brancard mentioned duration. Do we want to put duration in definitions, or would that be more appropriate in the permits?
I have a proposal, Mr. Chair. In that new subsection 2 in 400, that was C, sorry, 400C, new subsection 2, where it says the plans required of the applicant in section C1 shall be incorporated into the pilot project permit as enforceable conditions. The term of any pilot project permit shall not exceed 5 years.
Okay. Is that clear? So Ms. Orth is suggesting it's on the top of page 13, I believe.
Top of page 14.
Top of page 14, I'm sorry. New subsection 2 would have a duration, mention it specifically, 5 years. Now, that very likely would exceed the duration of the rule. Is that okay? I'm seeing attorneys' heads nod, so. Okay. So has everybody agreed to put a 5-year duration in new subsection? So this would be 400.C point subsection 2, new subsection 2. The duration would be listed as 5 years. Right? Okay. Let's go back to definitions.
Chair Thompson.
Yes, ma'am.
Since we're already on it, would subsection 2 be a good place to say that the department, no. I mean, we're already down in this section. Shall we define or shall we state the NMAC? That's what the capacity will be.
Is it clear? Commissioner Fry is suggesting at some place in the permit, NMAC is asked to establish what constitutes a pilot project.
So is capacity different from quantity of produced water?
I don't think so.
Because quantity of produced water is already required as part of the application in A(4).
Yes, but it doesn't define nowhere anywhere else in the reg. Is there a definition of what constitutes a pilot project as opposed to a demonstration project? Is that clear?
You lined out all the demonstration projects.
I know, but if it's not a pilot project, it would be a demonstration project.
Okay.
That's my interpretation. We want to just leave it up to the staff? It's a tough one. It would have helped if.
Chair Thompson,
Yes, ma'am.
I think I might have found it. So under B, authorized pilot projects, in that first paragraph, we could just state there that the department will we had the wording earlier and now I lost it. Something to the effect that determine the constraints of a pilot project or something to that effect.
Commissioner Brankard.
I have a sentence, you can figure out where to put it. The permit shall provide a maximum daily produced water capacity. I don't know what that means, but sounds good.
Like, sorry, Chair Thompson and Commissioner Brankard, Commissioner Zemlik. I think that's important because that's what goes in the notice, and anything outside of what is generally considered to be pilot scale, even if that determination was made by NMED, that could be challenged. So I think they should make that determination. I like Commissioner Brankard's sentence.
So can we add it to the sentence that I just read earlier? So say the words again.
Permit shall provide a maximum daily produced water capacity.
Permit shall provide a daily maximum capacity. Produced water capacity.
Yes.
Okay, so now at the top of page 14, the whole sentence that would be added after the words enforceable conditions would be the permit shall provide a daily maximum produced water capacity, and the term of any pilot project permit shall not exceed 5 years.
Yeah, Commissioner Brankard's has brought to my attention something that actually should be in the application. The application says that, so I'm looking at 400C. No, this is not the application. Yeah, I'm looking at, well, it's actually, it's the permit, produced water pilot project permit 400C1A Roman numeral, small Roman numeral 4. It says the quantity of produced water. That should be the daily quantity. Yeah, because if they're going to run this thing for 3 years, the quantity would be an enormous volume. Would be an enormous. Let's put the daily quantity or design capacity or something like that.
I have a question.
Yeah.
Commissioner Laney, so I was reading the new subsection 2, and It states that the plans required of the applicant in section C1 shall be incorporated into the pilot project permit as enforceable conditions. So their listing of the volume that they intend to use and all of the plans would be enforceable conditions. Is this overcomplicating it to add this extra narrative? I've gotten a little lost, so I'm hoping that once we've finished the discussion, we can go back over what we're intending to add. But to me, that statement reads that the plans are in fact part of the permit and therefore enforceable.
That's correct. That's how a lot of permits issued by the Environment Department
Yes.
are structured.
So do we need to add all of this extra language about the volume, or as part of the review of the permit application, NMED could determine whether or not that was sufficient? Are we trying to give NMED a tool that they're using to gauge whether or not a volume is appropriate or inappropriate? I've got a little lost in what we're hoping to give to this permit process and this permit. So maybe I just need some clarification before I can add more to the conversation.
I've gotten a little lost too. We've kind of gone in different directions. Commissioner Zemlich. Right, I'm sorry. I was just looking out of the corner of my own.
I believe Madam Hearing Officer has a sentence already to be added to that paragraph. Is that correct? Do we have a sentence that we're adding? I think that was about duration.
Right at the top of page 13. You see the language that was there this morning, and then just one sentence added after the words enforceable conditions. The plan permit shall provide a daily maximum produced water capacity, and the term of any pilot project permit shall not exceed 5 years. Is that what you're asking?
And that's the top of 14, correct? That new subsection 2?
Correct.
Okay. So I think that's all that we've changed. And now we're just wanting to discuss the capacity, and we're trying to decide if the current language already addresses that or if we need to add something. And Chair Thompson had suggested at least specifying in the permit that they are in the application that they state the daily.
In little 4, he inserted the word daily before the word quantity of produced water.
So does that get at what I think Commissioner Brankert was, or rather, does that address the fact that in the definition of a pilot project, we were taking out capacity and putting it down below? Is it already addressed down below so we don't have to have it in the definition?
I don't know. I've just been trying to think, is there another way we could define pilot project? And I think it just has to be based on capacity. And perhaps in the absence of testimony, best we can do is leave it up to the staff. As I said, I'm aware of other definitions of pilot projects for other types of projects, other types of treatment. But that was, we didn't receive any testimony on that. So I think we have to leave it up to staff. Commissioner,
Could I ask, where were you suggesting to add the word daily? I've lost that.
Little 4, right before quantity of produced water.
page 12.
So C1A3, little
4.
oh, well, the change would be in 3, correct?
No, this is
that
near
would
the
be in
bottom
4.
of page 12. Little 4 says the quantity of produced water. So now it would say the daily quantity of produced water.
Okay, so we've revised new subsection 2 there at the top of page 14 to put a duration, a 5-year duration. We have, I think we've agreed to remove a capacity limit in pilot projects. Is that correct? Okay, can we move on? Commissioner?
So I still come back to, do we need to say in here somewhere that the department will determine what a pilot or what the capacity of a pilot project will be? I thought somebody had said it would help both the department and the attorneys if we did say that.
Commissioner Molander?
That was me who said that. And could you repeat that again? I'm going to catch all that one more time, if you will.
So I'm asking, maybe suggesting that we need to add somewhere in the permitting section to say that the department will determine if the capacity posed is a pilot project.
Few thoughts on that. One, when you give discretion to an agency and you don't set a standard, you always have potential for abuse of discretion or industry confusion, market confusion. There's value generally in setting standards in the regs, so everybody knows what the rules are. But sometimes there are good instances where things are left in the discretion of an agency. So there's pros. I always give out the pros and cons of this. There's play in the joints on one side. I mean, that's probably surprises nobody who's worked with lawyers. Play in the joints with the agency can lead to some confusion, vagueness, etc. Also, potential for abuse. If something is put into a reg, I always try to remember fixing that reg is going to be a lot of work down the road if something is done, I won't say incorrectly or improperly, but an agency discovers, ooh, what we understood originally as a certain fact that would be governed by the reg isn't really the case, and you can end up with those issues. So I have a habit of both sides-isms, but that's what when I look at a reg or a rule, that's how I'm looking at it. Is how the other question, which I don't think is really an issue, is usually, does the agency really have that authority for the discretion? I think we're okay here from what I'm aware of, but yeah, so it's a double-edged sword. There can be consequences, but there can also be significant benefits.
I think Commissioner Lander makes a good point. One of the issues that I think may arise is that the oil and gas industry is facing some really difficult challenges with disposal of produced water. It's expensive, it's complicated, and I believe, in fact, we heard testimony to this effect from Mr. Hightower and from the Numoga folks, that they would like the ability to treat produce water for other uses to reduce the challenges they face with disposal. With that preamble, I think there's the potential to try to take advantage of this rule and build large pilot plants where the objective is actually to, well, the objective is twofold. One is to demonstrate that they can do it. But the second objective would be to get rid of some of this waste. So I think there would be benefit to the Environment Department staff if we, the commission, did put a cap on the size. Did I make myself clear? The industry has an incentive to make these pilot projects as big as possible. The Environment Department staff needs some authority so that they can respond to that request.
So I guess I have a couple of observations, if I might, Mr. Chair. One is you were asking about demonstration projects as opposed to pilot projects. The original definition of demonstration project included only bench scale and pilot. Anything bigger than bench scale is a pilot project. You did take out the industrial projects. So I had two recommendations with that. One is to briefly review the action and evaluation decisions made already by the Bureau and the Secretary and the Commission in 20.6.2 in the sections that we've been referring to between 3108 and 3113. The other one is to consider the possibility that you have a narrative rather than a numerical balancing, such as the one proposed by the community groups and NEE, which is in attachment A to my report at the top of page 43. It's a narrative. The evaluation, right, of the granting of the permit must consider the volume of produced water, the locations, the proposed activities, and the permit should only be granted if the department determines that the benefits of the proposed research outweigh the risks posed to health, safety, and the environment. So it's a much more subjective determination than 2,000 gallons or 2,000 barrels, but it may give the department the discretion you would like to give them to deny a permit application if it's especially scary looking.
Something else I would add to that too is that frequently agencies, if they decide they've got a policy about how they're going to apply this, that'll be noticed up to the regulated industry. And so that way it's not the same thing at all as a reg, but it will provide guardrails, information, kind of a sense of what the agency is expecting and what they've been doing with the same or similar instances they've encountered already. So that I'm going to make the assumption here that that's probably true within MED. So something else to keep in mind in following up on the hearing officer's comments.
Okay, well, two things. I do think it would be helpful to give the department a little bit of authority to establish capacity of these projects and not have it be dependent on what the applicant is proposing. Right? And so I can revise the sentence that I provided earlier. But I do also want to push back on the chair's comment that these could be large scale projects where the industry essentially is getting rid of produced water. We're not allowing pilot projects that can discharge. These are all non-discharging projects. So that by itself will limit, I think, how large these projects are, because people conducting the project will still have to dispose of some sort of liquid waste stream roughly equivalent to what started out in that liquid waste stream. So therefore, I would propose a sentence that reads, the department shall provide in the permit a maximum daily produced water capacity. I got rid of the passive voice anyway, that's better.
Okay. Another thought, and I was following up on the suggestion by Ms. Orth about the description, is we could perhaps include in the definition of pilot project that a pilot project is a project at a scale sufficient to determine the design parameters and performance of a full-scale project. So that would emphasize that the purpose was to develop design criteria and performance criteria, not to treat large volumes of water. But I'm comfortable. Commissioner Brancard's suggestion that the department shall provide maximum daily capacity helps, but that really doesn't provide guidance to staff on what the maximum size is. And I do appreciate your comment that since you can't dispose of the water, and that's going to constrain the size of a project.
Thompson.
Commissioner.
I just wanted to mention that probably for the department to consider is putting together justification for what those sizes may be. It's in the literature. It just wasn't in the evidence. And so I think there's sufficient information out there for the department to create defensible maximum, if that's what they choose to do, outside of this rulemaking.
Are we accomplishing anything?
Thompson.
Yes, ma'am.
So if it helps, I like the suggestion you just made on what to add to the definition, and I like what Commissioner Brancard had suggested for the permitting section. And I'm hoping that we don't have to be more specific than that.
Would you repeat the language?
I'm working on the language right now. Thank you. So the language that I'm scribbling down, this would be in addition to the definition of pilot project. So it would say the purpose of the pilot project is to develop design and performance criteria needed to design and construct a full-scale treatment plant. Yes, the purpose of a pilot project is to develop design and performance criteria needed to design and construct a full-scale treatment plant. Commissioner,
You said treatment plant,
yes.
technology? I mean, how do we know it's a plant? I mean,
System?
just,
I can't conceive of anything other than a treatment plant to manage this water.
well, but remember that there's a whole lot of ideas out there about using produced water in systems that don't involve, you know, closed loop systems, etc.
Are we entering into an area of concern to say industrial use?
Why don't we call it a treatment system? And I'll come back to Commissioner Fry's comment. And the reason I picked treatment system is because treatment is defined under T.
But is it only going to, this Commissioner Fry, is it only going to be used? I mean, these pilot projects are not just for the treatment of the water, but it's for use of the water at an industrial scale. I can't think of another word to use.
Well, I think the definition of pilot project doesn't need to determine what the ultimate use of the produced water is. The definition doesn't. I don't know.
So rather than treatment, system or process, could we just say, take out the word treatment and just say, I don't know, process or system? Might have to hear the sentence again.
The sentence is, the purpose of a pilot project is to develop design and performance criteria needed to design and construct a full-scale treatment system. That could be mechanical, chemical, or magical.
Mr. Chair, I kind of like what you're doing, because I think the definitions that we have now are really, really vague. And the initial definition of pilot project was intended to sort of distinguish it from a bench scale project.
Yes.
We've gotten rid of bench scale project. Okay. But of course, we have to consider, when we start getting more specific, are we narrowing the universe in some way? So I don't know, Commissioner Zemlich is familiar with projects that have been funded or proposed. Would they fit into what Mr. Thompson is proposing?
I think the distinction is that the pilot project is not the end result. It's not the intended end result, as Chair Thompson has said. All of the existing pilot projects are essentially like a larger proof of concept. So including the language, all right, get mixed up. Maybe I can pull from one of those. Mm. So reading from the existing projects language, like for pilot projects specifically, data collected from the trial will provide information to help develop. Well, that's regulations. It's essentially that they're larger than you can conduct in the lab, and they're conducted at a scale that you can then make a larger scale. But the pilot project itself is not intended to run independently for forever. I'm sorry, I'm not helping clear up the matter.
I would agree with that because it just occurred to me that these pilot projects, I think the intent is not just to develop systems for industrial use, for lack of a better word, term, but they are to help develop regulation. I think we should have that in there.
Standard.
Thank you.
Well, that's performance criteria.
Hmm.
Okay. So where do we stand? Are you comfortable with the language that I suggested? We'll take out the capacity and we will instead substitute that language. It's a narrative that describes what a pilot project is. And that will provide some assistance to staff on when they consider the application.
Chair Thompson, I still come back to, I think saying treatment systems is too narrow. What if we were to say systems that will utilize produced water or something like that?
Other thoughts? I can't envision a reuse application in which the water was not treated. I mean, even for deep well injection, they treat it. The treatment is just to remove suspended material and to adjust the chemistry so they don't have erosion or fouling. But it is treated.
The lawyer in me says you should look at the definitions of treated produced water and recycled produced water under the Produced Water Act. What you're talking about is, I believe, what the Produced Water Act refers to as recycled produced water. But a mechanical
Yes,
treatment.
but it does receive treatment.
Right. It's not officially treated produced water.
So I go back to my suggestion of instead of treatment system, say systems that reuse produced water.
Would you also want to consider the language that y'all spent a lot of time on in April, in which it was a series of terms? Discharge, transfer, storage, disposal, or distribution, which is part of the word treatment, right? I mean, that's where you're headed with that treatment.
Could we shorten that to, Chair Thompson, I don't remember the phrase you used. It was something about something criteria. I don't remember what your phrase was.
Performance criteria.
Yeah.
We are way down in the weeds. And I need help finding the way through the weeds. Commissioner Brancard.
How about you read your sentence again?
I'll do it. The purpose of a pilot project is to develop design and performance criteria needed to design and construct a full-scale treatment system.
Commissioner Fry.
Do you want me to go over what I just proposed instead? So replace treatment system with systems that would reuse produced water. And I keep forgetting.
Sorry. Can I get us to go back 2 steps in where we're at in the, is this the definition? So I don't think a definition should be the purpose. I think a definition needs to define what a pilot project means in the context of the rule. So I'm struggling with it being a purpose. I can't wrap my brain around it. The definition that we have plays out that it's non-laboratory environment. You know, it's beyond the bench scale, although we struck bench scale. I'm having a hard time with the language that we're looking at here. I'm more comfortable with what we started with, lest the additional sentence that we added in April, which was the water capacity equal to or less than 2,000 barrels per day. I'm having a hard time with defining a pilot project by defining its purpose. That's where I'm struggling here.
Commissioner Brancard.
Is what you're describing, Commissioner Thompson, a prototype system?
No. In engineering terminology, a prototype is full scale. A pilot is, as the language I'm offering, is a study to develop the design criteria so you can construct a prototype.
So is that an engineering scale model?
It is at a scale, yes. I don't like the term model because you're actually building something. So it's not a model. It's a pilot scale project, pilot scale treatment system, something like that. Not a model.
I'm just using the words that are already in the reg to see whether those are sufficient or not. That's all.
Well, and you know, we may be spending a lot of time on something that's not important. We have expressed a desire to provide some type of guardrails on the size of these things. We agree that it's not a capacity in terms of volume per day. Maybe we don't need it. Maybe the pilot scale is just obvious, or we can leave it up to staff. Mr. Bayless.
Thank you. First of all, I really like Commissioner Brancard's self-limiting notes that if you're going to have to take all the stuff that comes out of these pilot plants to a restricted disposal site, then you're actually limiting the size of what you can do. But I also thought it might be possible, since we're talking about full scale versus pilot scale, could it be beneficial in the application to have the proponent say what the full scale is? If like the full scale is 100,000 barrels a day, that's what they're designing for, and they should know what that number is. They should know what size of plant they're considering in the future. And then they would say, we propose a pilot scale test at X thousand gallons per day. And you could you could use the full scale to determine whether X is realistic or opportunistic.
Okay. Look, why don't we just set this aside for now? And we'll come back to it. Can we do that? We're just dealing with the definition of pilot scale. Can we deal with the other definitions? Come back with fresh perspective. Commissioner Brankard, you do not look happy.
Come back in the next half hour? I'm
Yes.
hoping you're done in the next half hour.
Okay, so using the prerogative of the chair, let's go on. Definition of potable, does anybody have any heartburn with that? That's pretty clear. In fact, I think that's out of the regs. Pre-treatment, any concerns about that? Produced water, I think this is another one that came out of the regulations, didn't it? Reclaimed wastewater, domestic wastewater. It's been treated. We've eliminated recycled produced water, and we've eliminated restoration application or ecological application. Reuse water, we shortened that. It eliminated the parenthetical comment or the parenthetical statement. S, terms beginning with S, state, surface water, terms beginning with T, we eliminated transference, treated produced water. We kept treated wastewater. We kept treatment. And we added transfer, storage, disposal, or distribution. And it looks like there's an asterisk there. So it looks like Ms. Orth added discharge, and I think that's a good addition.
That was what y'all had kept, and I had accidentally deleted it. Yeah.
Thank you. Terms beginning with U, untreated produced water. Untreated wastewater, pretty straightforward. Terms beginning with V, terms beginning with W, we eliminated water contaminant. We changed the definition of water pollutant to we just referred to the definition in 20.6.4. Water pollution, again, that's referred to the definition in the statute. Wastewater, again, we added discharge, transfer, storage, disposal, distribution, or reuse. Any concerns there? So that is all the definitions. Any other definitions we need to go back and revisit besides pilot project? Okay, 20.6.8 general provisions. Any concerns about those, Commissioner? Right? 20.6.8 101 through 0.8.199. That's all been eliminated, reserved. 20.6.8.200, which is domestic wastewater reuse, refers to direct and indirect potable applications. Yeah, I'm willing to let it stand, but if I was doing this from scratch, I would refer to the drinking water standards. But I think that's gonna, the department has assured us they're working on some criteria for this. So yeah. Any thoughts on direct and indirect potable reuse? Industrial wastewater reuse, which is 20.6.8.300. That's silent at present. And then we go to 400, which we spent all morning on. So let me ask, is the only remaining unresolved issue the definition of pilot project? I'm seeing some heads nod. So now that we've got fresh.
Chair Thompson,
Yes, ma'am, please.
can I try something and see how the rest of the commissioners feel about it? So pilot project means a representative engineering skill. I think that first sentence is fine. And then second sentence, a pilot project represents an increase in technological skill than otherwise achievable in a laboratory and often involves larger quantities of materials over longer periods of time. Maybe comma, maybe not comma, that is intended to lead or lead, well, I'll just say it the way I wrote it, intended to lead to full-scale produced water reuse. And then I'm still stuck on that last word, plants, perhaps. Systems. So it's part of one of the sentences. I'm trying to be simple. Because I like the idea of someone who's never heard of a pilot project before and they're reading this. As it stands, they don't understand. Okay, so it's more testing, but I think I like the idea of indicating that the next step then is the full scale thing.
Would you repeat what you said?
I don't fully like it, but so at the end of sentence 2, time, you end with time, comma, intended to lead to full-scale produced water reuse. It's not necessarily produced water. So full-scale reuse systems or plants or something along that line.
I have a question. Sorry,
Mm-hmm.
I'm still struggling. What does that clarify for us? I don't know if we're saying it's intended, okay, what does that really tell us? And what if they don't get there? What if their pilot project is a failure, but the intention was to lead to full scale? I'm not sure it clears anything up for me.
I feel like to define this for someone that's never heard of a pilot project, it's helpful for them to know why you do a pilot project.
But is it helpful in the context of this rule? That's what my question is. And I'm not sure that it's helping clarify what a pilot project is in the context of this rule beyond what was already laid out in the definition. And looking at the attachment A and kind of thinking about what was given in testimony, there wasn't a tremendous amount of argument over what a pilot project was during that time period. Everybody seemed to understand that fairly well. The only recommendation that the commission got, which was captured here in attachment A, was from, I don't know the acronyms, CGFCM and NEE, which was to add the cap that the chair had proposed at our April meeting. So I would argue that the definition as it is, given all the testimony that we've heard and all the input and the public comment, nowhere did it come up that the definition for a pilot project was confusing.
I don't object to leaving it as it is. I'm just saying, I think being the person that's tried to read rules with no background in them, and then seeing this definition that I don't understand. I'm thinking of more of general public than it seems like everybody that's going to be guided by this, maybe they don't need that. So maybe it's fine to leave it stand. It's just,
It's my nature to play devil's advocate. I apologize.
no, that's fine. I think to clarify who these definitions are for is meaningful.
As I see it, the definition is not for the general public because they're not going to read the rule. The definition is for the applicants and to help the staff evaluate the application.
And my last comment that I will make on this is we saw a lot of public comment about the definitions. So, I'm thinking maybe they will read this, but I'm happy to leave it stand, removing that last sentence about the capacity.
Sorry. Was there anywhere in the record where pilot projects? You're right. There were a lot of comments about definitions. I just don't remember pilot project being a specific one that was brought up.
Right. They definitely wanted to strike the term industrial projects, for example, and there was a lot of discussion about striking the definition of any terms that were not used in the rule or were used only in other definitions, and the commission went along with that mostly.
Commissioner Zemlich.
Chair Thompson, what I've noticed and recalled from previous testimony is that's sort of where demonstration projects came in and the confusion over those. And I might recommend that sort of what everybody's been describing is that part of what a pilot project is doing is demonstrating outside of a laboratory setting a proof of concept. So I'm happy with the definition as it is, because I think that among technical staff who would review and make decisions based on it, that's not a foreign concept. But I just wanted to offer that up as my recollection. Helps.
Scroll. Commissioner.
If you're looking for a recommendation, apologies, Commissioner Laney, my recommendation is still that we use the definition that was provided by NMED less the 2,000 barrels per day sentence. That's continues to be my recommendation.
Any other commissioners? Again, it's speculation on my part. Is that going to place NMED in a difficult position if someone comes in with a very large pilot proposal for a very large pilot plant?
So, Mr. Chairman, as I said earlier, there are some guardrails, if you will, or constraints, guidance to the department in terms of when they approve an application that can be found in 20.6.2. And so if it looks like it's going to be a hazard to public health, now I've lost what I was looking at, but it's in the sections you have now expressly referred to, 3109.
Yes.
And this is definitely the section that the department and perhaps the commission relies on when they're considering what special conditions need to be added and whether an application can be approved at all.
Thank you. Okay, it looks to me like we're agreeing to leave the definition as it stands, removing the last sentence, which describes the capacity, maximum capacity. Is that agreed? I see heads nodding all the way around, so we'll do that. We will just simply strike that last sentence. We've also struck in the beyond the bench scale phrase. Okay. All right. Is there anything else we need to revisit? Hearing none, it seems to me the last order of business is to pass a motion or to consider a motion to approve this proposed rule as amended. Is that correct? Commissioner Fry?
Can a motion be as simple as accepting this draft with the suggested changes made today? Or do we have to detail what the changes were today? And Commissioner Branco was shaking his head no.
Council?
I'm not sure what you were shaking your head no to.
I don't think we need to detail.
Okay,
As long
great.
as we have a sense of, there is a piece of paper out there that has everything that we have done. And we can reference that piece of paper, which may just be the scribbles of the hearing officer.
And the transcripts.
Right.
I agree. That was what I was gonna say, the former.
Okay. So I would entertain a motion to pass the proposed ground and surface water protection supplemental requirements for water reuse as amended in this meeting and last meeting. Commissioner Brancard.
So move. No, I move that we adopt Title 26, Chapter 6, Part 8, as proposed by the New Mexico Environment Department with the amendments made by this commission at the April meeting and the May meeting of the commission.
Thank you.
May I, I believe you said Title 6, it's Title 20.
Title 20, Chapter 6, Part 8.
Second.
It's been seconded by Commissioner Laney. You ready to vote? Okay, Mr. Lopez, or Ms. Jones?
That's fine. You can.
Should we do paper ballots?
Where's the chimney?
We need a chimney though, right? Yeah.
Okay. All right, we'll take a roll on this. Commissioner Barunda, who was on the virtual platform, had to step away. Commissioner Brancard, how do you vote?
Yes.
Commissioner Fry?
Yes.
Commissioner Laney?
Yes.
Commissioner Linger?
Abstain.
Commissioner Moander?
Abstain.
Chair Thompson?
Yes.
Commissioner Bayless?
Yes.
Commissioner Vigil?
Yes.
And Vice Chair Zemlik?
Yes.
That's 6 yes, 7 yeses. Motion passes, Mr. Chair.
Great. Thank you. Thank you very much, everybody. Especially the people that have sat through this. Okay, there's one other issue. We've got to have a statement of reasons. And the hearing officer prepared a statement of reasons, circulated it to us last week, I think.
And it needs to be substantially rewritten.
It needs to be rewritten to address some of the issues that we have, some of the changes we have incorporated today. So before, let me ask, Commissioner or the council, before this goes to the
State
records,
records.
the State Records Center, it needs to have a statement of reasons. Now, there's a deadline, May 24th. Does the statement of reasons also have to be submitted by May 24th?
I believe so, Chair.
Okay. So if that's true, then we can proceed a couple different ways. One is we can have a special meeting to consider the statement of reasons. Or two, I believe, and again, this will be to the council, the commission can authorize the chair to approve the statement of reasons, recognizing that it's going to be substantially the same as what was submitted earlier by the hearing officer, but it will incorporate the changes that we made today and yesterday.
I believe you're correct.
Those are the two options, I think.
And I have a question regarding the second path. Would it be allowable, Mr. Ugarte, for me to prepare a draft statement of reasons, to share it with the commissioners, to ask them for their individual input, not reply all, but individual input, and then forward that draft with whatever edits might be made to the chair and represent to him that I had input from the commissioners individually?
Madam Hearing Officer, I think that's appropriate.
Thank you.
So that's clear. The hearing officer will revise the statement of reasons, send it to y'all. You can communicate with her any changes that you think need to be done. She can incorporate them forward to me, and then I will sign it on behalf of the commission or approve it on behalf of the commission. Commissioner Brancard,
Do we need a motion to delegate the authority to the chair?
think so.
I move that we delegate the authority to the chair of the commission to sign and approve the statement of reasons when it's finalized.
I'll second. This is Commissioner Fry.
Further discussion? Ready to vote? Mr. Lopez, would you call roll?
Vote on Mr. Brinkard's motion. Commissioner Brinkard,
Yes.
Commissioner Fry,
Yes.
Commissioner Laney,
Yes.
Commissioner Linger,
Yes.
Commissioner Moander,
Yes.
Chair Thompson,
Yes.
Commissioner Vihil,
Yes.
Commissioner Zemlik.
Yes.
Motion passes.
Commissioner Bayless.
Oh,
Thank you.
sorry about that. Commissioner Bayless.
Yes.
Motion passes.
Okay, thank you. Is there anything else on 20.6.8? Is there anything else on any other topic? New business? Old business? Commissioner Fry?
On the agenda, next meeting date and adjournment.
Sorry?
On the agenda, we have next meeting date and adjournment.
Commissioner Brancard?
Mr. Chair, I'm just wondering at our next meeting, whether we have it in June or whatever, that we requested the Environment Department give us a presentation on all the legislation that was passed during the last session and all the future rulemakings that will be coming to this commission.
I will make that request because there are a couple of very substantive rulemakings that in conversations with NMAD staff, it looks like they're intending to propose these rules much sooner than I expected by the end of the year. So
Chair Thompson?
Yes, ma'am.
I'm wondering if it'd be reasonable to ask for a timeline for all.
Yes, of course. We'll do that. Okay, so our next meeting is the second Tuesday of the month, whatever that is. I don't, June 10th. Does anybody have concerns about that? Do we have a list of potential agenda items yet?
None yet.
Okay. You know, there's always the chance, and it has happened several times. That I want to let the new commissioners know. Probably one meeting out of 4 we cancel because we don't have any items of sufficient importance or time constraints. So cross your fingers. Maybe we'll have June off. All right. With that, I'd entertain a motion to adjourn.
So moved.
Second.
Thanks. We're done.
Thank you, Mr. Chair. Bye. Can I get off? Okay, good. Okay.